today we are going to talk about technology transfer under the context of IP. In recent years, if you are already in China, you may realize and you may read some of the high-level statements have been made about abandoning unfair technology transfers against foreign companies. However, still, there are many European companies are still concerned about forced technology transfer. In which scenarios, for example, like the information leakage during the IP registration, sharing documents with Chinese partners, and the requirements of extensive documents from the authorities, not only the central government, but also the local government. And we will discuss how to avoid the IP risk during the technology transfer today, including what is technology transfer and how to do background searches, which is due diligence on business partner. And we will see what is the consideration when you sign contract with your partners. And there are also a few case studies you can read from the real European companies who are trying to do business in China. So what exactly technology transfer? As you may already imagine, it includes data, register IP, trade secrets from the technology owner to the other parties. And what kind of ways those technology can be transferred? There are many methods you can think about. For instance, before you decide to transfer your technology to China, you must want to consult some consultancy company. When you consult, and those some of the technology or some of the technical information will be shared with those consultancy company. And also it's possible that some students join those graduating programs, overseas one, and they can also bring those technology from different from China to Europe or the other way around. And if you decide to have R&D, including the collaborative research in China, it's that kind of research usually involves two or more than two parties. And in that situation, most of the time, it's the pattern or know-how which is transferred. And I also want to mention about when patenting your technology in China, it is possible to be transferred in China. Like when you apply for patent registration, it also means the technology transfer from you to other parties. That in that case, it's the Chinese authority, because registration means patent being published in that jurisdiction. And after the authorities decide to publish that, everyone can see your technology. And I want to mention that patent right is territorial rights. If you only protect in Europe, not in China, but the Chinese companies can read your patent technical information from the Europe Patent Office. And in that case, without protection in China, it will be like free license in China. Therefore, the patent registration in international markets, including China, is very important. And the other things about patent and technology protection is that during the patent registration procedures, a patent application for invention using some kind of data resources could be asked to disclose by the Chinese authority. In this case, it's China National IP Administration, CNIPA. For example, the data related with genetic resources will need to be disclosed with disclosed to CNIPA. Otherwise, the patent application using that data could be refused or to be regarded as being withdrawn. That will be the loss for your patent registration. I recommend you consulting a patent attorney in China when registering your patent in China, to making sure the data or the information you share with the CNIPA is compliance and also sufficient. And most of the companies, when they transfer the technology to China, usually it's via licensee. Licensing allows the third party to use your technology. And for the licensed technology, there exists certain risk of leakage. I would recommend you to protect your IP before making the decision to license to Chinese companies. We will go through more details of the license later. And about the spin-off companies, usually that was set with a very clear purpose between European or Chinese, among European and Chinese companies. And joint venture is the most common type of spin-off companies. We will also go through joint venture in more details later. And if you're a European company and you want to import your technology to China, the first thing you should check is a catalog for prohibited and restricted technology import. That is the technology import catalog. Why is it important? Because you will see if your technology can be imported to China. If it is not, the foundation of your business negotiation with the Chinese partners, it's not there. And you don't want that, you don't want to realize that you cannot even bring your technology to China after months or years of negotiation. And that's why it's important to check these technology import catalogs. And the second one is for the export. And why is it also important? Because probably in the future, you want to export your technology from China to Europe. And if you can only import it, not being able to export it, it may damage your business as well. And the latest version of the import catalog is 2021. If you read the import catalog, you may realize it's actually pretty short. But if you read the catalog for the exports, you will realize it's much longer than the import one. So those two catalogs has totally different content. And one thing I want to mention is about the technology export catalog. The latest version was only released last month. And the major change of the export catalog is strengthen China's technology sovereignty in EVs, renewables, and semiconductors. And it's likely to cause some supply chain problems for foreign companies for battery materials and other ones to chips. And companies overseas that rely on Chinese lithium and gallium are going to feel the most problem with this export, the latest export catalog. And if you read those two catalogs, you will realize they classify the technology to freely importable or exportable, and restricted one. Restricted one, that means you still can import, export the technology under certain permission. And the permission procedure was, it includes two steps of getting the permission from the government. First step, you have to submit an application to the local commerce department. It's not from the MOFCOM, it's not the Ministry of Commerce, but the local one. And the application will be either granted or denied within 30 working days. When it's approved, you will receive a letter of intent for import-export license. So you get this license, government approve the export or import of the restricted technology. It's not done yet. Second step, you can sign the technology transfer contract with your Chinese partner. And the contract has to be submitted again for the final approval. The approval for the second step will only take 10 working days. It's shorter. Then you will receive the final license of technology import or export. And you have to get this permission before signing the contract with any of your partners. Otherwise, you cannot legally enforce your rights without getting the letter of intent or the consent from the permission from the government. So it's really important if your technology is restricted according to the catalogs. And the third types of technology is prohibited one. Everyone knows that you cannot do anything about those prohibited technology. So it's important to check both catalogs and know whether or not you can import or export your technology. before you're doing business in China. What I just mentioned, the catalog is just the first step. And second step, you have to check negative list for foreign investment. And the latest version was released last year. According to the latest version, there is no restriction on foreign investment accessing the manufacturing sector anymore, which is great news for European company. However, the restrictions still remain in telecommunication, education, healthcare, transportation, mostly services industry. So you should also check this negative list. And why you have to check that? Because in that list, it categorizes those goods and services, not only the technology, into three types. First is free to invest. Therefore, that means there's no restriction. You can set up a wholly foreign owned company. You can also set up a joint venture or licensing your technology to China. Second types of investment is restricted. That means you have to establish certain types of company, for example, like joint venture in China. And in some situation, the Chinese partner has to hold certain type of shares in that joint venture. It's listed in the negative list. The third types is prohibited. That means you cannot, as foreign company, you cannot invest at all. That's why it's important to check, because it's related to your investment. And on the contrary, there is an encouraged industries catalog. As you can tell, those industries listed in this catalog are favored for the foreign companies to invest in China. If your industry is in that catalog, you may enjoy the tax exemption, the funds, and the other advantage from local or central government. So please also check the negative list and the encouraged industries catalog. Besides checking those lists, which should be done before you come to China, you should also make sure you know your business partners in China well. Therefore, doing the due diligence is very important. And I know a lot of European companies may not have the local resources or find it very difficult to understand China. But it's still possible to do the background search on your own. And you can use the national official database. Its name is National Enterprise Credit Information Publicity System. You can see here, this is the link, and this is how the website look. Probably you can use translator to see the information. And if you cannot use it, then please contact us or contact the Chamber of Commerce or even embassies to ask for favor. From this website, you can learn every Chinese company about their legal representative, capital, business types, and what kind of business they are doing, the date of establishment, those basic information. You can also see whether or not they are still in normal function during their daily business. Because some of the companies may already in a negotiation with a Chinese company, and then it turns out that Chinese company should have been bankrupt a few years ago. That means you shouldn't do any business with that kind of company. And that kind of information you can easily find out from this database. And from this database, you can also read whether or not that Chinese company has been disputed in the past, like the contract breaching situation or any IP infringement in the past. And you can download the annual report of the Chinese company as well. However, one information that a lot of companies, European company, want to know, annual turnover, it's not listed in this website, or unless the company choose to publish. However, 99% of the company choose not to publish that. So from the annual report or from this website, you may not be able to read how much turnover the Chinese company made. And for you to easily navigate this company, we also made a short video about how to do the background search to a Chinese company. You can follow the step. And when you handle the meeting with the business partner from China, you should have a protocol before you do that, before you attend a trade fair in China, or before you fly over the half of the earth to come to China and try to make a deal. There are some of this example of how to handle the meeting with your Chinese partner. It's not an exclusive list. So before the discussion, you should prepare an NDA, which should be in Chinese and also in English, and do the background search to your Chinese partner, like I just mentioned. And when you share information, make sure those sensitive information should be only viewed at your business property at a later stage, and before that, only share those rough sketches or very general idea of your technology, especially those core ones. And when the negotiation reached to a certain stage, make sure you sign the MOU, just outline the structure of the deal, what information to share, and make sure you make it very clear of the disclosure obligation of both parties. And when you sign the final contract, that will include not only include the information you already covered in the previous negotiation, but also make it very clear that who owes what information and what information to be exchanged, and also the non-disclosure obligation of both parties. And afterwards, you should be able to continue to monitor your business partner. And in the contract, you can also give yourself the right to pay announced visit to the Chinese plant or Chinese partners' plants to make sure they follow the confidentiality obligation or the contract you both parties signed. And we already mentioned there are many ways of technology transfer, including licensing and joint venture and wholly foreign owned enterprises. For licensing, this is the most common way to transfer technology because it's much easier than the other types. You don't need to set up a new company in China. However, it has the least control of IP. There are many reasons. First, it might be because you have license to several suppliers in China. That means you share your IP with different parties, different companies, and to avoid that kind of risk, it's always possible to use the modular strategy. That means you have different suppliers for different components, and none of them know how to assemble the final products. That's licensing. And we have a very good case study later on to illustrate what is modular strategy. And I believe a lot of the European companies who are in China already do it. The second types of structure is joint venture. Like I said, joint venture usually has a very clear purpose. It's usually combining the advantage such as the technology from European side and the sale and the marketing from China side. So it has its own business efficiency. It's selected by most of the European companies who want to establish business in China. However, make sure you can establish joint venture by checking the negative list. And the IP leakage risk is lower than the license because you as a European company still part of the JV. However, you share more information with your Chinese partners. So I wouldn't say the IP risk of JV is the lowest. However, but if you look at the WFOE, because you have the fully control of your IP, of the company, how the company run, so the IP control is the highest. But if you want to establish a WFOE, you have to check the negative list again to make sure your industry, your sectors is allowed to set up a WFOE in China. I want to talk about joint venture. In the contract, when you side with the Chinese partner, what is the consideration and what's the important clauses to make it very clear that the purpose of this joint venture and how it runs. So in the joint venture agreement, you should make sure it's very clear what kind of business relationship you are and why you decide to set up this joint venture, what business goal it's going to achieve in certain amount of time, and what kind of company it will be, and in terms of the share, and who are the owner, who are the owners, who are the shareholders should be listed very clearly. And in terms of the parties' contribution, like capital and IPR, you should also make it very clear. And the shares, including profits, liability, risk, tax, and fees, these issues should be covered with your Chinese partner through maybe many rounds of the negotiations. But these are important topics about joint venture. And also, it's important to make it clear of which party control which part of the joint venture and how the protocol of decision making looks like. And there are two more IP-related issues. It's the ownership of the improvements of technology. The first type is the employee invention, or for those technology which is improved by the employee. A lot of companies will miss this topic before signing the joint venture agreement. So according to the Chinese law, you should not forbid your employee to make any improvements to the technology. However, what you can do is in your contract, making it very clear that after they make these improvements, you should be the owner, and as a return, you should give those invention employees reasonable rewards. And according to the latest patent regulation, there is a very clear number of how much awards they should get. And the money you set in your contract shouldn't be lower than that. As far as I remember, those number for the invention patents for 1,000 RMB, and for the design or utility model, it's 1,500 RMB. It's not very high. Making sure in the contract it's not lower than that. And if in the contract you didn't mention about that rewards, according to the law, you will still need to pay the employees who improve the technology that amount of money or even more. And that's the improvements made by the employees. What if that improvement is actually done by the Chinese side? Is it still allowed? According to Chinese law, yes, it is allowed, and you cannot forbid them to do it. Therefore, in the contract, if it claims that the European company automatically owed the ownership of the improvement made by the Chinese side, that clause may not be able to enforce in the future. Again, when you draft and before you sign the joint venture, you should consult with an experienced lawyer in China to make sure each provision is enforceable in the future. And with the licensing agreement, there are also a few clauses you should pay attention to. First, it's the definition of the use of IP should be very clear. What type of IP you want to license to your Chinese partner. And second is you should make sure you can monitor the licenses activities to make sure they are not going to authorize that technology to any other party without your consent. And prevent your technology from being transferred to the third party without your permission. And reverse engineering, like most of you already know, that it is allowed to conduct that. You cannot forbid the license. You cannot forbid your Chinese partner from doing it. However, if when they conduct the reverse engineering and it infringe your patent rights or trade secret, then it is illegal. And if the provision in your license agreement just forbids reverse engineering without the detailed definition of what it's or the examples of what are the prohibited actions are, it could be unenforceable in the future as well. So be careful with this topic, reverse engineerings, and it's not as simple as you thought that you just put a sentence that reverse engineering is forbidden according to this contract. And of course, always protect your confidential information. That should be done by the NDA and also later by the license agreement. And remember that IP is territorial right. Your European IP doesn't mean you have protection in China. And the saying that you can only enforce your IP rights, which is protected in China, and the applicable law is Chinese law for IP dispute. A lot of companies I know, they only set the license agreement to last for 2 or 3 years, and after that they will renew it and to update the contract. It's not a bad idea. It's totally fine. But making sure after you terminate the contract, you should have the right to ask your Chinese partner to return those documents and data and sensitive information to you without asking to get the compensation or get the rewards, because that's your right. And in terms of the language, most of the license agreement I notice from the European companies signing with their Chinese company are only in English. That's not right. You should include a Chinese version, because that will make sure the Chinese party understand your expectation. You do not have misunderstanding between each other. And I already mentioned several provisions to avoid or not to be enforceable in the future. This is just a summary and extra bits of those provisions you should avoid. First, you should avoid to prohibit a licensee from making improvements to the licensed technology. And in your contract, you cannot set unreasonable restraint on a licensee's procurement channels, such as how they purchase raw materials, how they purchase equipment. And you shouldn't set unreasonable restraints of the quality, price, sales channel as well. And you cannot exclude any rewards to an employee for his or her patented creation. We already talked about that. And IP is territorial right. So you have to make sure it's the Chinese law to be governed. You should use the Chinese law to govern the Chinese IP dispute. You cannot use non-Chinese law to govern the Chinese IP dispute. And we have 2 case studies. The first is about modular strategy. The one I already mentioned about licensing, and it's a combination of the WFOE in this case. It's quite interesting. So this European company that designs, manufactures, and sells tattoos chair. And before they come to China, they already check the catalogs I mentioned and also the negative list I mentioned. It turns out there's no restriction, there's no prohibition. So they can either set a WFOE or even set JV and licensing their technology to China, no problem. And the purpose of their coming to China is that they want to reduce the manufacturing cost and enter the growing market for tattoo chairs in China. So before they come to China, they already start to protect their technology by registering core technology as patent in China. And they use the modular strategy, including the core technology remains manufactured in Europe and shipped to the WFOE located in Shanghai. And they license their technology to one factory to manufacture the seat pads and another factory to manufacture the metal frame. So different suppliers has different jobs in terms of providing the components, and the final assembly takes place at the WFOE. And later on, when the WFOE also engage in R&D activities, the employees, they are part of those innovation improvement. And before they did, they already signed an agreement to make sure the European company or the employee inventions. Of course, the precondition is the European company will pay the reasonable awards to the employee. They also make sure they sign a non-compete agreement with the product development manager, which usually lasts for 2 years. This case shows that it's important to register patents to your technology in China, and you should use different manufacturers for different components, and also keep critical components offshore and have the final assembly at a WFOE or offshore to make sure you have full control over it. Use the contract to address the ownership of employee invention. And the second case is about licensing, and it's about when the IP infringement took place, how to enforce your rights. So for this European company who is in chemistry industry, they license the know-how, include software to Chinese companies to help them building up chemistry plants. And before they signed the agreement, they did a lot of work, a lot of due diligence works into selecting Chinese company. Eventually, they decide to work with a Chinese company, which is the top one in the industry in China. And they also signed a separate agreement authorizing their Chinese partner to handle the enforcement in China due to the language barrier and due to the legal resources limitation from the European SME. To protect their trade secrets, they make sure all the technical documents are delivered using double strong encryption with triple encryption used for key equipment. And they only provide the documents and the technology on a need-to-know basis. And the technical documents contain hidden markers that identify them as IP. So they did all the steps they can think about to protect their trade secrets. However, the infringements still take place. It's from the former employees in key position. They stole the confidential documents before they left the company and sold to a new plant in another province. The SME and the Chinese partner decide to take actions to enforce themselves. So firstly, they contact the local Public Security Bureau, PSB, and they file a criminal complaint. In the situation of trade secrets infringement, you have to ask support from the police. They will make the investigation much easier, and also building up the case. So the police started the investigation to get the drawings, and they hire an expert witness to compare the original drawings and the drawings from the new plants, and to confirm that this is a trade secret infringement case. Afterwards, the police issued a countrywide warrant to search and arrest the former employees. One of the employees already has been arrested, and the other one still at large. And the new plant, it's already proceeding with the installation and production, unfortunately. And the SMEs try to contact different institutions, different enforcement department to make sure their remedies, they try everything to enforce themselves. So you can see it's not only in China, they also did quite a lot of things in EU and international level. However, this case is still pending, and we don't know what's the result, and we hope the SME will get the compensation and get the remedies they deserve. From this case, can see that it's important to take various measures to protect confidential business information as trade secrets. And also the leakage of trade secrets by former employees is the most common one. So make sure you sign the agreements with the key employees. And it's not cheap to enforce IP rights in China. It's easily cost more than 10,000 euro. However, if you do not stop the first IP infringement in China, you will attract more infringements in the future. And if you unfortunately encounter any IP infringement in China, you should contact IP experts as soon as possible. And lastly, I leave some takeaway messages. Protect your IP when transferring technology to China, and refer to the catalogs I mentioned, import and export, as well as the negative list for foreign investment before bringing your technology to China. And make sure you do the due diligence to your potential business partner in China and develop a protocol to deal with the Chinese partner during the negotiation, and use China IP experts to help draft your contracts to ensure the protection of your IPR. And you can always contact us